sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
I have created a Patreon page for those of you who want to support my channel. All patrons will receive access to the new private bond court Discord server. All video content will remain on my YouTube channel for free. Supporting me on Patreon is not required, but it is greatly appreciated. Thank you to everyone for watching my channel, liking my videos, and leaving comments. Bond court is now in session.
Taylor Fleming on behalf of the Office of the State Attorney.
Letitia George on behalf of the Office of the Public Defender.
All right, thank you both. Yes, ma'am. This is fine. We're gonna figure it out. Okay. Joshua Ben Yah.
Approaching, Your Honor.
Mr. Yah, you're charged with trespass on an occupied structure and refusing to leave. The court does find probable cause for that charge and sets a bond of $500.
Your Honor, state did convey an offer to Mr. Yaw of an adjudication of guilt, credit time served, and no return.
How much time served does he have?
2 days.
Does your client wish to accept that?
No, Your Honor, he wishes to,
All right. Case will be scheduled for pretrial arraignments. The conditions of release are as follows. You are not to return to the location where this incident occurred and have no contact with the victim.
okay, that's why there's a bond, it's 100 with the bill.
Weston Jackson.
Approaching, Your Honor.
Mr. Jackson, in your case, the court finds probable cause for petty theft with 2 priors. Bond stays at $2,500. There's probable cause for count 2, resisting an office without violence. Bond stays at $100. And count 3, criminal mischief. Bond stays at $100. Thank you, sir.
Your Honor, state would ask for a no return and no contact.
The court will also order as a condition of bond that you not return to the location of this incident and have no contact with the victim. Is this an arraignment?
Yes, it's a move up.
Oh, okay. Alonzo Wayne Pender.
Yes.
Sir, you're here for an arraignment on a charge of driving while your license was suspended or revoked with knowledge.
And
How does your client wish to enter his plea?
he's going to enter a plea of no contest, Your Honor. The offer from the state is an adjudication of guilt, credit time served, and court costs, and Mr. Pender would like to accept.
All right. Have you checked his driving record to be sure he's not going to be in danger of becoming an habitual traffic offender with this plea?
Yes, Your Honor. He has one from 2005 and one from 2008.
All right. And how does he wish to enter his plea today?
No contest, Your Honor.
All right. Mr. Pender, is this your signature here at the bottom of this plea form?
Yes.
Did you read the plea form in its entirety before you signed it?
Yes.
Are you under the influence of any alcohol or drugs or medication this afternoon?
No.
Do you understand that by pleading no contest, you're giving up all the rights on the plea form? Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen? All right, sir. Are you stipulating that there's a factual basis, Ms. George?
Yes, Your Honor.
There is a sufficient factual basis. You're alert, you're intelligent. I'll adjudicate you guilty. Order 6 days in the Warrant County Jail with credit for the 6 days you have served, and to order you to pay mandatory court costs. Court costs must be paid within 180 days of your release, and I am ordering your release as to this charge. Do you have any questions? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. Okay, Jeffrey Martin Puryear.
Yes. Good afternoon, Your Honor. Michael Cahill on behalf of Mr. Puryear.
All right, sir, you were picked up for failing to appear. Looks like a violation of probation, and bond is set at no bond on that.
Your Honor, we'll enter a denial as to the violation of probation, and Your Honor, I would ask the court to release Mr. Puryear on his own recognizance, or in the alternative, set a reasonable bond in this case. I have filed a motion to set bond. I reached out to the Assistant State Attorney assigned to Division 61 for this case, Mr. Simmons. He doesn't have any objection to Mr. Puryear being released on his own recognizance in this case, and I've shown this to ASA Fleming. And she doesn't have any objection, I don't believe, to him being released on his own recognizance. This was a case where he was issued a notice to appear for a violation of probation for not completing treatment. The notice was mailed to his home address, and for whatever reason, he didn't see it, or it got lost in the mail or something, and he subsequently did not appear when this case was set on June 1st. He doesn't have any previous failures to appear. And, Your Honor, I believe that the technical violation of probation should be cleared up. The matter of treatment is the only thing that's violating him. So, Your Honor, based on all those reasons, we would ask that the court release him on his own recognizance. He has hired me to represent him for the case, and I will ensure that he appears at any future court dates.
State, are you aware of whether or not this defendant has completed the other conditions of his probation, including the DUI counterattack class, the victim awareness class, the community service hours?
It is, to my knowledge, from the ASA notes from the ASA on the case, it appears that the only thing left, as Mr. Cahill has put on record, is the treatment and any, or evaluation and any recommended treatment. So it does appear he's done everything else. That's why state has no objection to an ROR, given that the ASA on the case also has no objection to an ROR. But I do believe the only thing he has left is that eval and any recommended treatment at this time.
All right, and has anyone reached out to the judge assigned to this case to see if the judge is in agreement with this, either you or the other assigned ASA?
And not to my knowledge, Your Honor.
All right, counsel, who's the judge?
Judge Johnson.
As soon as you reach out to Judge Johnson's JA and confirm that Judge Johnson has no objection, I'll be glad to.
Okay. I reached out to Judge Johnson's JA yesterday. Judge Johnson's currently on vacation.
Oh,
I
okay.
think his JA indicated that someone might be covering for him, so I don't know, but.
I
this
don't
was
know who
the-
his backup is. It's not me. Not sure. Can you find out who his backup is by asking his JA? She'll tell you.
Okay,
And then you can reach out to that person.
okay. I already have the motion filed and the order prepared, so.
If you want to do that right now, that's fine, and I'll rule on it now. Otherwise, I'll just leave it at no bond, and you can set it in the division.
Okay. Yeah, I don't have any form of technology with me. It's
Oh, I'm sorry to hear that.
trials of coming into the
well,
jail.
Okay, well, these cases, generally, when the judge orders a particular bond, I defer to the judge. And so, giving deference to the judge who ordered the no bond, I'm gonna leave it at no bond.
Okay.
And I'll set it for the VOP status.
VOP status, June 28th at 10 o'clock, courtroom 7C.
Yes, ma'am.
Thank you, Your Honor.
All right, thank you.
Your Honor, we have Vargas as medical.
All right, Jeremy Vargas was appointed to the public defender, is not here due to medical reasons. Set for an arraignment.
Your Honor, I will waive and enter a plea of not guilty.
All right, set this case for pretrial.
Division 62, pretrial conference, July 28th at 8:30, courtroom 12C.
Is the other one in Division 62 also?
Actually, that one is Division 61, pretrial conference, July 15th at 1:30 p.m., courtroom 7C.
David Ward Bain.
He's medical also, Your Honor.
All right, and the public defender was appointed in Mr. Bain's case.
I will waive and enter a plea of not guilty, Your
All
Honor.
right, we'll set that for pretrial conference. He only had one case.
Division 82, pretrial conference, July 26th at 9 o'clock, courtroom 9B.
Cordarius Butler.
approaching, Your Honor.
All right, Mr. Butler, you're here for an arraignment on a charge of battery, domestic violence. The public defender was previously appointed on this case, Ms. George.
It's a VOP.
Oh, it's actually on the underlying, it's actually on a violation of probation. The underlying charge is battery, domestic violence.
And we will enter denial, Your Honor.
All right, denial is entered. We'll set this case on VOP docket.
Division 50, VOP status, July 18th at 9 o'clock, courtroom 4E.
Thank you. Brianna Lee Walker.
Your Honor, she is medical also.
All right, Ms. Walker was appointed to be represented by the public defender, Ms. George.
I will waive and enter a plea of not guilty.
All right, plea of not guilty entered, and we can set this case for pretrial conference.
Division 85, pretrial conference, June 27th at 9 o'clock, courtroom 4A.
Anita Denowitz. Yes, ma'am. Ms. Denowitz, let me see these glasses. Out of them. Ma'am, I find probable cause for this offensive trespass on a structure or a conveyance. Is there a plea in this case?
There was an offer, Your Honor, to resolve.
Yes.
However, she has no criminal history and will likely qualify for pretrial diversion. And
Then I'll set bond in this case at $500.
Your Honor.
Sorry, $250.
Your Honor, I did speak with the state. I would ask for an ROR, given she has no history, no failures to appear. The state has no objection, Your Honor.
State?
State has no objection to an ROR with the condition of a no return with the exception of one time to gather belongings.
Okay. What, the ROR is granted. Why would I be doing the condition of a one-time return?
I believe she was living at that
I'm
establishment.
not gonna do that. ROR and no return, no return.
And Your Honor, the only reason, all her, like, everything she has is there. She, like, her phone, everything. I would ask for just the one-time return with law enforcement to gather something. She literally was living in the hotel, and that was the issue. She has everything there, which is why she can't even post the bond. So we would just ask, if she's escorted by police, at least to grab something, because she's gonna get released. She's not gonna have anything, Your Honor.
All right. A one-time return with law enforcement to recover personal belongings, of which that return must be done within 24 hours of release. After that, do not go back to the facility.
Your Honor, we have James Moore as mental health.
All right, Mr. Moore, the court would find probable cause in that case and appoint the public defender if you wish to waive his appearance.
I will waive his appearance, Your Honor, and I would also ask that he be screened for mental health pretrial release. I believe there's some competency concerns there based on the affidavit.
As to this gentleman, Mr. Moore, the court finds probable cause and would order that the defendant be screened for mental health pretrial release. Do you want me to still set the bond?
Yes, Your Honor.
Or a bond of $250? Public defenders appointed. Thank you.
Your Honor, state would ask for a no return.
In court's ordering no return to the location where this incident occurred. As a condition of bond or release, Brandon, Ruby Rivas. Well, these are really out of order. Ruby Rivas. Are you Ruby Rivas?
What's the inmate number, Your Honor?
Brandon, are you Brandon?
Yes, ma'am.
Okay, here, Ruby Rivas. What happened to Ruby Rivas?
2201-3082.
He bonded.
All right, bonded per the jail staff. As to Rivas, Mr. Wool, the court finds probable cause in your case of petty theft, and bond will stay at $250. Additionally, the court is ordering you to not return to the location where this incident occurred as a condition of bond. Court will take no action on the out on bond case.
Your Honor, we have,
Ma'am, so is this a misdemeanor or felony? Why can't I talk to her? Why not? Is this a misdemeanor or felony?
I'm gonna let Ms. George answer that for you.
Oh, I can't talk to the judge. Yes, I can. I know the law.
Sir,
Yes, I can.
sir, you can talk to me,
Yeah,
but
that's
since,
what I'm saying. Don't lie to me and tell me I can't.
well, but since Ms. George has been appointed to represent you, I just wanted her to answer the
Way
question.
over there, and I was just asking a simple question. The misdemeanor felony is very simple.
Okay, yes,
Like, come on.
yes. Tequila Alsemi.
Your Honor, she is behavior.
All right, as to Ms. Alsemi,
I will waive the appearance, Your Honor.
all right, appearance is waived, the defendant's appointed to be represented by the Public Defender's Office. The court finds probable cause, or the defendant was picked up actually for contempt of court for violation of an injunction, and bond will be set at $2,500 in that case. Court's ordering no contact with the victim, comply with the terms of the injunction as a condition of bond. Ryan Cornelius. In your case, sir, you were picked up for failure to appear, and bond will stay set at $1,000 in your case.
Your Honor, state did convey an offer to Mr. Cornelius of a withhold of adjudication, credit time served, no return, no contact with the victim, restitution in the amount of $30, and cost of investigation of $142.50 to OPD. I also did inform the PD that he may qualify for PTD.
All right, Ms. George?
Your Honor, if you would like to accept it, enter a plea of no contest.
All right, even though he might qualify for pretrial diversion, he wants to still resolve it today?
Yes, Your Honor.
Okay. Mr. Ryan Cornelius, is this your signature here at the bottom of this plea form? Did you read this plea form in its entirety before you signed it? Are you under the influence of any alcohol or drugs and medicine this afternoon? Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Okay.
You understand that? There's a sufficient factual basis. You're alert, you're intelligent. At this time, I will withhold adjudication of guilt. Order, how much time, sir?
2 days.
2 days in jail, quarter for 2 days, time served. Order you to have no contact with the victim and not return to the location where this incident occurred. Further, you must pay $30 in restitution, as well as $142.50 cost of investigation to OPD. Who's the restitution payable to, state?
Bad as sandwich.
Thank you. And you have a restitution order ready for me?
Yes, Your Honor.
Okay, thank you. Sir, do you have any questions? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir.
Thank you.
Ashia Robinson. You are charged with violation of conditions of pretrial release, 3 counts, and bond will stay set at $100 per count.
For trespassing, yeah, cool. There you go. It's 100. The attorney.
Your Honor, we have Diaz Lopez as bonded,
Okay.
and we also have Garcia Mejias bonded.
Okay, hold on a minute. Diaz Lopez is bonded. Okay, Garcia Mejias is next. But I don't have a sheet on him. Okay, Garcia Mejias is also bonded per the staff. So next is Plesac, Michael Plesac.
Your Honor, may I approach?
Approaching, Your Honor.
Yes. Thank you. As to Plesac, in the court finds probable cause for count 1, driving on a suspended license with knowledge. Bond stays at, you do qualify for PTR, so I'll order PTR on all counts or a bond on count 1 of $500. Probable cause on count 2 for violation of a DL restriction, bond, PTR or bond of $100. And count 3, expired driver's license, PTR or a bond of $100. Conditions of PTR and or bond is that you do not drive without a valid driver's license.
Your Honor, we have Aponte as mental health.
I will,
Mari Aponte, defense public defender is waiving. I will appoint the public defender, of course. The court does find probable cause as to all counts. Count 1, bond is set at $1,000. Count 2, bond is set at $150. Count 3, bond is set at $150. Count 4, bond is set at $100. William Carrera, Mercedes.
Yes, Your Honor.
Sir, the court finds probable cause, and you have 2 cases. The first case, possession of methamphetamine. Bond will stay set at $3,000 in that case. In your other case, the petty theft charge, bond is set at $250. And you are ordered to not return to the location where this incident occurred and have no contact with the victim as a condition of the bond. Thank you. Sylvania Chambers. Ma'am, in your case, the court finds probable cause for burglary of a dwelling with an assault or a battery with a weapon. The weapon in this case was a bat. It was not a gun, so you have any objection to me? What, do you have a suggestion as to the bond?
Your Honor, given that it is a first-degree felony that is punishable by life, state's asking for no bond at this time.
Well, if it's a bat, it's not a gun.
The weapon doesn't matter. If there's.
Are you sure about that? Because I looked at the statute and all I saw was gun. Firearm. I didn't see anything about other kinds of weapons.
Yes, sure. There doesn't have to be a weapon, period. And
I beg your pardon?
a burg dwelling with an assault or battery, without a weapon in general, just a battery. So if she just used her hands, it'd still be a PPL.
So looking at the statute, though, is what I'm saying. I did not see an indication of a generic indication of a weapon. And so, and the bond schedule does not have a generic, just a weapon. It's only as to firearms. So it's kind of.
I believe it reads, burglary is a felony of the first degree, punishable by a term of years not exceeding life imprisonment. If in the course of committing the offense, the offender makes an assault or battery or becomes armed or uses a weapon, and then enters an occupied dwelling or structure. So it's has an assault or battery or is armed or becomes armed and enters that dwelling.
Is armed or becomes armed.
Yes. So it's or assault or battery or is armed or.
Okay, assault or battery or becomes armed in the course of committing the burglary. So you're already there, and then you pick up a bat and start beating somebody, then it's still a PBL? Okay. All right, well, I'm gonna go with that. But the bond schedule does not make a distinction of, there is no weapon. It's only firearm. Do you see what I'm saying? But it does still say PBL, but it's a firearm. It's not a bat or some other kind of weapon, nunchucks, whatever.
Okay.
So it's not really confusing, it's just not there.
Clear, not concise.
Yes, it's not there. So, but the becoming armed in the course of, I think covers it. And so I will grant your motion, and bond will remain set at no bond. As to count 2, criminal mischief bond is set at $250. Conditions are that you have no contact whatsoever with the victim, not return to the location where the incident occurred, not possess any firearms or weapons of any kind, and surrender any weapons in your possession or firearms in your possession to law enforcement within 24 hours of release. Yes, ma'am.
I don't have her in my stack, Your Honor. However, I would make the argument that even if it is a punishable by life offense, you do have the discretion per the statute to set a bond if given the facts and the circumstances it warrants one. And
it's some pretty bad facts. I mean, the facts warrant no bond. It's just that I wasn't 100% sure whether or not I could do no bond without a firearm being involved. These are not good facts.
However, Your Honor, I would ask that you consider, based on, and this is based on, because I don't have the sheet in front of me, based on my clients telling me that she has no criminal history. So I'd ask that you consider the fact that she has no criminal history in
Miss
this case.
Miss Fleming, can you confirm that she has no criminal history? I gave my paperwork already. I gave it back.
On my face sheet, she does not. I can double check CCIS. However, Your Honor, she is 19, so she is still fairly young, and this is a very serious offense.
Yeah, it's very serious.
I
What
do believe the
happened?
victim was also hospitalized afterwards. Her mother had to speak to law enforcement. I just believe this would be better heard when the victim could appear at an Arthur hearing later down the road. Even though she has no criminal history, she is young, and she started off with a fairly serious, rather violent offense.
It is a very serious offense. It is extraordinarily violent. I am very concerned about the offense, which is why I had the conversation with the state about whether I was required to do a bond. Since there was no firearm involved, a bat can kill somebody just like a firearm can if it's used in a certain way, and this bat was being used in a certain way. I'm comfortable with the no bond at this time, understanding, ma'am, that you can file a motion, or your attorney can on your behalf, where witnesses could be present and those who are involved, victims and others, can have an opportunity to be heard, and the judge can make a decision if they want to, at that time, give you a bond. And the amount of the bond, right now, I'm gonna leave it at no bond status. Thank you. Christopher Costa.
Present, Your Honor.
All right, Mr. Costa, in your case, the court finds probable cause for carrying a concealed firearm. Bond stays at $2,500, and possession of paraphernalia, of which bond stays at $100. As a condition of bond, you are ordered to possess no firearms or weapons and surrender any in your possession to law enforcement within 24 hours of your release. Thank you, sir. Joshua Davis.
Your Honor, he's refusal.
Mr. Davis is a refusal?
Yes.
All right.
Your Honor.
I am appointing the public defender in the case.
I will waive the appearance, Your Honor.
All right, court finds probable cause on all counts. Count 1, bond is set at $2,500. Count 2, bond stays at $1,000. Count 3, bond is set at $150. Count 4, bond is set at $150. Count 5, bond is set at $100. Count 6, bond is set at $100. Patrick Donald. Yes, ma'am. Mr. Donald, in your case, sir, the court finds probable cause of possession of 3,4-methylene methamphetamine, MDMA ecstasy, and bond is staying at $1,000. Bond is revoked on 22 CF 13288AO, and a new bond is ordered for $2,000 on count 1 and $200 on count 2.
Your
We
Honor,
only filed on the possession of a controlled.
Oh, I'm sorry, okay, what, Ms. George?
They only filed on the possession of a controlled substance, Your Honor.
That is correct, Your Honor.
They only filed on count 1?
Yes, Your Honor.
All right, count 1, bond is doubled to $2,000. No action on count 2. Arthur Danton.
Yes, ma'am.
All right, in your case, sir, the court finds probable cause for failure to report after vacating your residence and sets a bond of $3,500. And you're ordered to report to the sheriff's office to register immediately upon your release or immediately upon your ability to post your bond. Thank you, sir.
Your Honor, he has another case as well.
Oh, does he? Let me see here. I guess I overlooked that one because I don't have any notes on here. Okay. Oh, I totally overlooked it. All right, hold on one moment. The court finds probable cause for count 1 robbery. Bond is set at $5,000. And the court finds probable cause for aggravated battery. Bond is set at $1,500. You're ordered to have no contact with the victim, not return to the location where this incident occurred, and possess no weapons or firearms, and surrender any in your possession to law enforcement within 24 hours of your release. Thank you. David Fallon. The court finds probable cause for count 1 burglary of a structure. Bond stays at $1,000. Count 2 criminal mischief. Bond stays at $100. And count 3 petty theft. Bond stays at $100. The conditions of your bond are that you have no contact with the victim. In this case, that you not return to the location where this incident occurred, and that you possess no weapons or firearms, and surrender any in your possession to law enforcement within 24 hours of your release. Thank you, sir. Tyree Green.
Present, Your Honor.
So this says Lynn Edward Green. Okay, let me see. Tyree? Lynn? Okay. Lynn Edward Green, in your case.
Is he here? Is he here? Oh, sorry.
The court finds probable cause for delivery of a controlled substance within 1,000 feet of a specified area. Bond stays at what was that? I'm gonna do $10,000. $10,000. Count 2, conspiracy to sell or deliver MDMA ecstasy. Bond stays at $15,000. Count 3, sale or delivery of 3,4-methylamphetamine MDMA. Bond is set at $150. And count 4, possession of 3,4-methylamphetamine MDMA. And bond is set at $150. Thank you, sir.
This one.
Oh.
This is not showing a 33 at my moment.
Mr. Green, I am also ordering that you have no contact with the co-defendant in this case. Tyree?
Present, Your Honor.
Tyree Green? Mr. Tyree Green? Sir, the court notes that you were picked up here for failure to appear on 2 counts. Bond will stay set at 0, bond on both counts. Thank you, Mr. Green. Mr. Derek Griffin. All right, Derek Griffin. So you have 8 cases and you're for failure to appear in First case 21 CF 12710 AO. I believe the bond is no bond on all of these cases, but bond will stay at no bond for failure to appear. And as to 21 12714 AO, bond stays at no bond.
CF 12954.
No bond.
2021 CF 13178.
No bond.
2021 CF 12951.
Thank you. No bond.
2021 CF 12900.
No bond.
2021 CF 2021 CF 12730.
And that's no bond as well.
2021 CF 12948.
No bond. All right, thank you, sir.
Your Honor, if I may,
Yes.
I believe the clerk, the restitution order I gave you, I believe was incorrect for Mr. Cornelius. May I approach with a correct one?
Yes, yes, you may.
I believe inadvertently I put 90 instead of 30.
Okay.
It should be 30, so here's a corrected, and I already showed it.
Did you already, you didn't file that yet, did you? Okay, then you could just chunk that.
Thank you.
All right, thank you. All right. Got some moisture in my throat now. Kayla Hanson. All right, ma'am, in your case, the court finds probable cause for count 1, possession of cocaine. And bond is set at $1,000. Count 2, possession of paraphernalia. Bond is set at $100.
There you go.
Christopher Holbrooks. As to the charge of grand theft 3rd degree, the court finds probable cause and bond stays at $1,500. You're ordered to have no contact with the victim and not to return to the location where this incident occurred. Cortez Jackson.
Present, Your Honor.
Mr. Jackson, as to possession of cocaine with intent to sell or deliver with a weapon, bond is set at $15,000. Count 2, possession of a weapon by a convicted felon, bond is stays at $150. And tampering with physical evidence, count 3, bond stays at $150. As to your second case of retail theft, bond is stays at $500.
And Your Honor, I did have a challenge to the possession of cocaine with intent to sell or deliver with a weapon. In case number 2022 CF 6554 AO, I would argue there is no PC, as the only thing the officer found on my client allegedly was the drugs. There was no scales, there were no large amounts of cash. There was nothing in the vehicle to indicate that he was intending to sell drugs, and so therefore I would argue that you find PC only for simple possession and not as to possession with intent to sell with a weapon, Your Honor.
What says the state?
Your Honor, I say there's no objection. There is no other indicia of sale, as Ms. George has already put on record.
All right, then I'll grant that motion. As to count 2, count 1, the court finds, you don't have no objection to me finding probable cause for possession of cocaine.
In possession of cocaine or possession of cocaine with a weapon, I believe either, Your Honor.
Okay, possession of a cocaine with a weapon.
And I'm trying to find the statute for the clerk now. Your Honor, possession of cocaine with a weapon is an F2, so it's down from an F1 to an F2. The statute for the clerk is 819.13 sub 6 sub A.
And as to that count, I'll set bond at $7,500. Thank you.
Your Honor, we have Shelby Lennon as behavior.
All right, are you waiving Shelby Lennon's appearance, Ms. George? And
Yes, Your Honor.
all right, the court notes this defendant was picked up for failure to appear, and bond will stay set at $5,000 on that count. Public defenders appointed. Andrew Robert McGrath. In your case, the court finds probable cause for count 1, possession of paraphernalia, bond is $100. Count 2, tampering with physical evidence, bond stays at $1,000. Thank you, sir. Staple these. Much better. Yeah, much better. Diego Mejia. In your case, sir, the court does find probable cause for count 1, possession of cocaine, bond stays at $1,000. Count 2, possession of methamphetamine, bond is set at $150. Count 3, possession of fentanyl, bond is set at $150. And count 4, possession of paraphernalia, bond is set at $100. Thank you, Mr.
We have Monk Darius as mental health.
All right, and that's as to Mr. Monk, which the court did find probable cause and appoints the public defender.
And I will waive the here.
All right, bond is set at $2,500 in the case of battery by detainee in a detention facility. As to burglary of a conveyance, count 1, bond is set at $3,500, and count 2, bond is set at $100. Court is ordering the defendant to have no contact with the victim and not to return to the location where the incident occurred.
Go ahead, Papa.
All right. Kane Popoff?
Yes, Your Honor.
Mr. Popoff, in your case, you were picked up for 4 counts of failure to appear, and bond will stay set at no bond on each count. Thank you, sir. Raven Schaefer. As to count 1, possession of methamphetamine, bond is going to stay at $1,000. I do find probable cause for that charge. And as to count 2, I find probable cause and bond stays at $100. Sir, the court will take no action on your other case that you are out on bond on at this time.
Your Honor, we have Jermaine Smith as mental health.
And I am appointing the public defender.
And I will waive the appearance.
Court finds probable cause on count 1, battery on an emergency medical care provider, and bond stays at $1,500, and count 2, assault on an emergency medical care provider. Bond stays at $100. Why did I write on here that he had 2 cases? He have 2 cases? No. By mistake.
Your Honor, state we just asked for a no return and no contact.
Yes, court will order no return to the location where this incident occurred and no contact with the victim. On the next case, which, yeah, okay. Richard Smith? Yes. Mr. Smith, in your case, sir, the court finds probable cause for possession of cocaine. Bond stays at $1,000. And count 2, possession of paraphernalia. Bond will be set at $150. Thank you, sir.
Your Honor, we have Monique Wilson as outside medical.
All right, I am appointing the public defender.
I will waive the appearance.
All right, the court did not find probable cause as to count 1, the aggravated assault charge. However, I did find probable cause as to count 2, battery, and bond is set at $500, and count 3, petty theft, bond is set at $150.
Your Honor, state would ask for a 24-hour reset to perfect count 1.
The court will grant a 24-hour reset as to count 1. As to the conditions of bond on count 2 and count 3, the court has ordered no contact with the victim and no return. Possess no weapons and no firearms, and surrender any in their possession to law enforcement within 24 hours of release. Thank you. Xavier Wilson. Mr. Wilson, in your case, the court finds probable cause for possession of 3,4-methylene, methamphetamine, MDMA, ecstasy. Bond is set at $1,000. Count 2, carrying a concealed firearm. Bond is set at $150. Count 3, grand theft. Bond is set at $150. And for neglect of a child, bond is set at $150. On your other case where you're out on bond, the court will take no action.
Your Honor, state would ask for no contact with the child and no weapons.
The court is ordering you have no contact with the child in this case, and no contact with the victims, all victims, and the mother of the child, and that you do not return to the location where this incident occurred. Sean Wajcik. Mr. Wajcik, the court finds probable cause for DUI. Third violation within 10 years. Bond is set at $2,500. Condition of bond is that you submit to random alcohol monitoring and you consume no alcohol while out on bond. That you do not drive without a valid driver's license. J. Robinson Young.
Mr. Wojcik also has a probation violation.
Oh, merci.
Interstate contact, so it doesn't come to our.
Okay. Never mind, Your Honor.
Okay. Okay. Jay Young. Mr. Young, the court finds probable cause for possession of a controlled substance, and bond stays at $1,500.
Your Honor,
Yes, ma'am.
you said no.
It was interviewed, so I don't know, they wouldn't take it back, like, interview.
Okay. Your Honor, I would just ask that given, I was seeing if he qualified, because they just stated they couldn't reach anyone.
Okay.
He has lived in the Orlando area for over a year. He has no criminal history.
Are you asking me for PTR?
I'm asking for an ROR because she said they won't
Okay, ROR is not an option, but
not-
I thought if you were asking for PTR, I would at least have him evaluate him, but are you saying they've already evaluated him for PTR?
Yes.
Okay, and he didn't qualify?
It just states that they couldn't reach his community ties. So I would just ask, could he?
Okay, wait a minute. Do you have community ties that they can reach?
At this time.
No, I'm asking the lawyer. Okay.
He stated his father lives here, Your Honor, so that's why.
Well-
Normally, sometimes they call and then no one answers the phone, so they may try again.
Well, what do? Do you call again when nobody answers the phone? Do you try a second time? Is it one and done, or do you try again if the person is able?
The time, and I think that was around.
I'm not gonna ROR him, but if he can provide community ties and he qualifies, I would order that he be re-evaluated for PTR if he qualifies.
Okay, thank you, Your Honor.
So, will you give a bond 1,500 or PTR if qualifies?
Yes, that's that's exactly right. PTR if he qualifies, or a $1,500 bond.
Okay, thank you.
All right, thank you all. Madam Clerk, what else?
12.
Anything else?
Okay.
Yes, ma'am. Okay.
Yeah, I do. I'm just, when I do them, I make sure. I will. I'm gonna do it right now.
Where is in recess? These things happen. Every now and again, on purpose.
Good afternoon, everybody. This is Judge Arendis. I will be handling initial appearances today. When I call your name, you're going to come up to the microphone. I will ask you to state your name and date of birth to make sure I have the correct person. I will let you know what charges you have been picked up on, if there is a bond, and what the conditions of that bond are. If you have not already applied for the services of the public defender and you think that you're going to need their services, you will need to complete an application. Their services will only be provisionally appointed for today, so you will follow up with that application if you need their services. We can have appearances for the record, starting with the state.
Rachel Klein-Peter on behalf of the state.
Pretrial release
Patricia Jenkins on behalf of pretrial release.
and defense.
Janelle Clark on behalf of the Public Defender's Office.
Thank you. Ms. Clark, if you have a probable cause challenge, please let me know when I call the case.
Yes, Your Honor.
Thank you. First case, Alberto Cruz Jorge.
PD provisionally appointed.
Yes, Your Honor, I have a probable cause argument for this.
You don't need to say that on everyone because I already did it on the record.
Oh, okay. Making sure.
Good afternoon, Your Honor. This is Laura Arroyo, State Certified Interpreter and previously sworn today.
Good afternoon, Ms. Aurora. This is Judge Arendis. I am in Osceola Courtroom for Echo. We are doing initial appearances, and the first case up for you today is 22MM1289. Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor. Por favor, indique su nombre y fecha de nacimiento.
Adalberto Cruz Jorge, 12-12-80.
Repita su nombre despacio.
Adalberto Cruz Jorge, y la fecha mía de nacimiento es 12-12-80.
Adalberto Cruz Jorge, my date of birth is 12-12-80.
Thank you. Sir, you've been picked up as a result of battery, simple touch, or strike, domestic.
Señor, usted fue detenido por un acto de agresión física en un caso de violencia doméstica por simplemente tocar o golpear.
As well as contempt of court for violation of an injunction for protection domestic violence.
También se le acusa de desacato por haber infringido las condiciones de la orden de alejamiento por violencia doméstica.
Defense, you had a probable cause argument?
Yes, Your Honor. With this defendant, the injunction that he was served, it was served in English. He's a Spanish speaker. In addition, he only has a second-grade education, and so he asked his children to help him interpret the injunction.
All right, I'm going to need you to hold on. Remember, we have an interpreter.
¿Acaso la defensa tiene algún argumento que hacer con respecto a los indicios razonables de criminalidad? Sí, su señoría. Con respecto al acusado aquí hoy día, la orden de alejamiento que él recibió estaba en inglés y él simplemente habla español y tiene estudios de solo hasta segundo grado. Por lo tanto, tuvo que pedirle a sus hijos que le tradujeran.
Due to his education, he had difficulty reading the forms that we had here in Spanish. And it was clear that he had no understanding of what the injunction actually meant.
Debido a los estudios que él ha recibido, él estaba teniendo dificultades pudiendo leer aquí hoy día los formularios que tenemos y por lo tanto no pudo tampoco entender la orden de alejamiento. ¿Entendió?
You cut out a little bit. Could you repeat that last part for him, Miss Interpreter?
I will start from the beginning because I don't know which part of the last part you're referring to. Debido a sus estudios limitados, él aquí hoy día demostró tener dificultades leyendo el formulario en español que tenemos aquí y por ende también tuvo dificultades leyendo la orden de alejamiento que él recibió.
So lastly, Your Honor, he has 4 children that live in the home with him, separate, unrelated to this case of the children that he has with the alleged victim in this case. So I was asking for a reasonable bond for him.
Y por último, su señoría, él tiene 4 hijos que son aparte y por separado a los hijos que tiene con la supuesta víctima en el presente caso y por lo tanto solicitamos una fianza razonable para él.
I'm sorry, Counselor, are you making a probable cause challenge or are you asking for reasonable bond?
Discúlpeme, licenciada, ¿acaso usted está planteando argumentos de indicios razonables o está solicitando una fianza? Ambos, su señoría.
As to the probable cause challenge, that will be denied.
Con respecto al argumento de indicios de criminalidad, será denegado.
According to the charging affidavit, he knew enough to drop his things and began walking away out of the Home Depot.
Con respecto al informe acusatorio, él supo lo suficiente para soltar las cosas que tenía y empezar a caminar fuera de la tienda de Home Depot.
Which tells me he knew that he was not to have any contact with her.
Lo cual me hace entender que él bien sabía que estaba prohibido tener ningún tipo de trato con ella.
No. Oh, you just spoke English.
I think he was responding to the interpreter, Your Honor.
But he said, I'm sorry, counsel, that's English. In any event, let me finish.
Usted acaba de hablar en inglés. No, su señoría, él estaba respondiendo lo que estaba recibiendo en español. No, licenciada, disculpe, pero eso estaba en inglés. Permítame continuar.
Counsel, your comments are unwarranted.
Y, licenciada, los comentarios suyos no vienen al caso.
It would be pretrial release with a bond.
Será libertad provisional con fianza.
Bond on count 1 will be set in the amount of $500.
La fianza en el primer cargo se fijará en $500.
Bond on count 2 will be set in the amount of $1,000.
La fianza con respecto al segundo cargo se fijará en $1,000.
Sir, you are to abide by all of the terms and conditions of the injunction that was served on you on June 3rd.
Señor, usted tiene que acatarse a todos los términos y las condiciones que forman parte de esa orden de alejamiento que usted recibió el 3 de junio.
You're not to have any contact with Perla Español.
Prohibido usted tener ningún tipo de trato con Proa Español.
No contact means no in-person contact.
Cuando le digo que no puede tener ningún tipo de contacto, no puede ser en persona.
You are not allowed to have anyone else contact her.
Ni tampoco permitir que alguien más se comunique con ella.
You are not allowed to contact her by telephone.
No está permitido usted comunicarse con ella por teléfono.
You are not allowed to contact her through social media.
Ni tampoco a través de medios sociales.
You are not allowed to contact her through the children.
Y tampoco lo puede hacer a través de los hijos suyos.
It means no contact whatsoever. Do you understand?
Esto significa ningún contacto en absoluto con ella. ¿Entendido?
Sí.
Yes.
Thank you, sir. You may have a seat.
Su señoría, si se me permite.
Is he allowed to have contact through a third party in order to deal with his children?
No, ma'am.
¿Acaso se le permite a él tener contacto con ella a través de un tercero para así poder tener contacto con sus hijos? No, señora.
I said no contact through third parties.
Le acabo de decir que no puede tener ningún tipo de contacto con ella a través de terceros.
Thank you, sir. You may have a seat.
Gracias, señor. Ya puede tomar asiento.
Next court date on demand.
La próxima vista será por notificación.
Ms. Aurora, would you mind making an announcement to see if we have anyone else needing your services?
Yes, of course. ¿Acaso hay alguien más que requiere los servicios de un intérprete en español? Si es así, por favor, levante la mano.
I see no hands.
Thank you. Thank you, Ms. Aurora. Have a good day.
You too. Thank you. The interpreter will disconnect.
Manodrov Nazaire. Good afternoon, sir. State your name and date of birth, please.
My name is Ronald Naziab, March 3rd, 1989.
Sir, you've been picked up as the result of a warrant out of Orange County for case number 48-2022-CF-64970. There's no bond on that, sir. They'll be notified that you're here and ready for pickup. Thank you. Have a seat, please. Omar Aguilar.
And the PDs are already on this case, Judge.
Okay. Good afternoon, sir. State your name and date of birth, please.
Omar Aguilar, 32880.
I'm sorry, can you repeat the date of birth?
32880.
Thank you, sir. You've been picked up as a result of 3 cases. There is a warrant for failure to appear in case 21 CF 1371. There's no bond. There's a warrant for failure to appear in 20 CF 411. There's no bond. And then there's a warrant for failure to appear in 21 CF 3717. There's also no bond. Thank you, sir.
Judge, that last case is 2019.
Huh?
The last case is 2019 CF.
Are you sure?
There should be a 2021, a 2020, and a 2019.
Oh, you're correct. It's 2019 CF 3717. My apologies.
Next court date for all 3 cases will be June 22nd at 9 a.m. in courtroom 5F.
Michael Cano. Good afternoon, sir. State your name and date of birth.
Michael Cano, May 20, 2000.
Thank you. Mr. Cano, you've been picked up as a result of a violation of probation warrant issued in 19 CF 708. There's no bond on that, sir. Thank you.
Next court date, June 20th at 8:45 a.m. in courtroom 5F.
Enuris Ortiz Rivera.
He refused.
All right, well, I will be waiving his appearance. He is picked up as a result of a warrant for failure to appear in 21 CT 1449. There's no bond.
Next court date, June 16th at 8:05 a.m. in courtroom 4A.
Leroy Shepard, VFOSC. Good afternoon, sir. State your name and date of birth, please.
Leroy Shepard Jr., 9/12/82.
Thank you. Sir, you've been picked up as a result of violation of probation or community control in case number 18 CF 1232. There's no bond on that, sir. Thank you.
Next court date, June 21st at 8:30 a.m. in courtroom 4F.
Mirtha Aquino Nunez.
Can you repeat that, Your Honor?
Mirtha Aquino Nunez.
She's in the hospital, Your Honor.
All right, then we will take care of her when she comes back.
Is there a specific set time or just when she's?
When she's released. Victor Martinez Merced.
He's detoxing, Your Honor.
We will take care of him when he gets out of detox. Martinez Merced. Toggy Pass. Good afternoon, sir. State your name and date of birth, please.
Togi Passage 012693.
Thank you. Sir, you've been picked up as a result of domestic battery by strangulation. Court has reviewed the charging affidavit. I do find there's sufficient probable cause. You qualify for pretrial release with a bond. That bond will be in the amount of $3,500. You are not to return to 5394 Cedar Point Way. You can go back one time with the assistance of law enforcement to obtain only your personal items. You're not to have any contact with Primrose Letterlod. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes, ma'am.
Thank you. Additionally, you're not to have any alcohol or drugs, you're not to consume or possess them, and I want you to report for random urine analysis. Now, I understand you want to say something, but before you say that, you need to know that everything you're saying is being recorded, and the state can use it against you. With that in mind, do you wish to say something?
1 second, Your Honor, let me speak to him, please.
To last conditions you said.
No alcohol, no drugs, random urine analysis.
Thank you.
Your Honor, the residence that you named, he wanted to let you know that that's where he lives. The alleged victim does not live there. That's his
Well,
apartment.
at this time, he can't go back there.
He can't go back to his apartment, Your Honor?
Not today, no ma'am.
Okay.
Thank you.
Next court date on demand.
Maria Reynoso. Good afternoon, ma'am. State your name and date of birth, please.
Maria Reynoso, 11/25/58.
Thank you. Ms. Reynoso, you have been picked up as a result of aggravated assault as well as battery, simple touch domestic on a victim 65 years of age or older. Court has reviewed the charging affidavit. I do find there's sufficient probable cause as to both counts. You qualify, no, you do not qualify for pretrial release. Bond on count 1 will be set in the amount of $2,500. Count 2, the amount of $1,000. You're not to return to 2361 Lily Pad Lane. You can go back one time with the assistance of law enforcement to obtain your personal items. You're not allowed to have any contact with Miguel Reynoso. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. You're not allowed to possess any weapons or firearms. I see that the two of you share a business or a company that you run together. You're going to have to let him handle things, or he's going to have to remove himself, but you're not allowed to have any contact.
Next court date on demand.
Excuse me, Your Honor.
Yes, ma'am?
He is not part of the business.
All right, I'm just going off of what the charging affidavit said. Just don't have any contact, okay? Thank you. Stephen Rolone. Good afternoon, sir. State your name and date of birth, please. Hold on, she's got to turn the microphone on. Go ahead.
Stephen Rolone, March 7, 1997.
Thank you. Sir, you've been picked up on a couple of matters. The first one is trafficking in cannabis, possession of drug paraphernalia, and possession of a firearm during the commission of a felony. Court has reviewed the charging affidavit. I do find that there is sufficient probable cause. Bond to be set on count 1 in the amount of $2,500. Count 2, the amount of $50,000. Count 3, the amount of $500. You are not to return to 211 Dalton Drive, and you're not to possess or consume any alcohol or drugs or possess any weapons or firearms. Additionally, you've been picked up with regard to robbery, sudden snatching, unarmed, and battery, touch, or strike. The court has reviewed the charging affidavit. I do find that there is sufficient probable cause. Bond to be set on count 1 in the amount of $1,000. Count 2, the amount of $1,000. You're not to have any contact with Stephanie Warren. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes, Your Honor.
Additionally, you're not to return to 5875 West Earl of Bronson Memorial Highway. You're not to possess any weapons or firearms. Thank you.
Next court date on demand.
Lejeune Stewart.
Good morning, Your Honor.
Good afternoon.
Good afternoon.
How are you, Mr. King?
Excellent. How about you?
I am fantastic. Thank you for asking. Are you representing Mr. Stewart?
Yes, on behalf of Attorney Philip Arroyo.
Sir, could you state your name and date of birth, please?
LeJohn Stewart, 11/14/2000.
Thank you. Mr. Stewart, you've been picked up as a result of battery, touch, or strike. Mr. King, did you wish to be heard, or are you just here to get a reasonable bond?
Your Honor, we'd request a reasonable bond and a no hostile contact order if the court would grant it. The other party is going to be filing a declination of prosecution later. I don't know if they're present. I don't think that they are.
They're not here.
Yeah, that's all we would ask, Your Honor, but we leave it in the court's discretion.
All right, Mr. Stewart, as I said, you've been picked up as a result of battery, touch, or strike. Court has found probable cause after review of the affidavit. Bond to be set in the amount of $1,000. You are not to return to 7600 West Earl Bronson Memorial Highway. You're not to have any contact with Destiny Rogers. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever until such time as this case is dropped. Do you understand?
Yes, ma'am.
Thank you, sir. Good luck to you. Anything further, Mr. King?
No, Your Honor. Good to see you. Thank you.
Good to see you. Have a great afternoon. Thank you.
Next court date on demand. Judge, there was a case that they, PTR wanted to bring up again. It was a case from yesterday, William Messick. He was seen yesterday for tampering with an electronic monitoring device.
Yes.
You were told that he was out on probation. It's actually out on Probable. So they would like for you to go back on the record and remove the on view because it's not probation, it's Probable.
Okay, but do I have any paperwork?
No, because it was after the.
So that's a problem.
Yes, I can print it out for you if you'd like to.
I mean, I'm not going to make a ruling without seeing paperwork.
Yes, ma'am.
Counsel, do you have anyone else over there that we haven't seen today?
Yes, everybody was saying.
All right, thank you. Have a good afternoon.
Thank you.
I mean, I vaguely remember the case because I remember defense counsel asking me not to say what the charges were out loud.
Here you go.
Ms. Jenkins, it is not probation, it is parole.
Yes, ma'am.
Ooh.
Ew.
All right, the court will be revoking the order of revoking the probation. Just sounds.
Okay, this is your preliminary hearing, Mr. Perkins. I just want to caution you that anything you say here is not privileged or private. Don't say anything that you would not want the whole world to hear. For the record, this is position 29, State of Georgia versus Temujin, T-M-U-J-I-N, Perkins. Mr. Perkins is charged in warrant number 2022 WA08236 with committing the offense of theft by shoplifting. Mr. Perkins is also charged in warrant number 2022 WA08237 with committing the offense of obstructing of an officer. Mr. Perkins is present here today. He's represented by Mr. Little. The state is represented by Ms. Jefferson. Ms. Jefferson, would you swear in your witness and present your case?
Officer, would you raise your right hand, please? Do you swear or affirm the testimony that you are about to give in these proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And you can lower your hand. And if you could state your name and where you're employed.
Yes, ma'am. My name is Kate Lam. I'm employed with the City of Mara Police Department since 2020.
And were you so employed on May 17th, 2022?
Yes, ma'am. I'm still employed with the City of Mara PD.
Okay. And on that day, May 17th, 2022, were you dispatched to the South Lake Mall, I guess an apparel store on South Lake Circle in Clayton County, Georgia?
Yes, ma'am, that's correct. That's in the South Lake Mall, Clayton County.
Okay. Was this in reference to a shoplifting?
Yes, ma'am.
And can you tell us the basis or the facts to support the charges of theft by shoplifting and obstruction that were taken against Mr. Perkins?
Yes, ma'am. When I received the dispatch call and I was received another information that the suspect was left from the mall security heading to the Olive Garden, restaurant where I met with the mall security that advised me meet the Mr. Perkins was inside the restaurant. So I get in the restaurant and located him while he was sitting on the table, and I was with the mall security that was him. At that time, I taking him into the custody for shoplifting. While I handcuffed him, he say he wanted to go to the prison, and after he get out, he will start again. And then I asked for his name. He say find out. He told me to find out, which I did. So I find out that his name is Mr. Jamar.
You said Jamar?
Saying Jamaring Perkins.
Oh, yes.
Yeah.
Just one moment. I'm getting a Zoom invite to join somebody in courtroom 3 or room 3.
Oh,
I'm not sure if that's for me, which I kind of think not, but I'm going to say not now.
Yeah, Your Honor, we got the same thing for.
I clicked on the button to open all rooms because I'm still trying to find Mr. Lane, but I'm listening. He's off in digital world, but that was me. I did that.
Okay, so we're declining.
Okay. Go ahead, Ms. Jefferson.
Officer, can you tell us more about the warrant for the shoplifting? Did you observe the shoplifting? Did you observe the video surveillance noting the shoplifting, or did you get information from mall security or from the store security about the shoplifting?
Oh, yes, ma'am. So I was advised by the mall security and the store employee that Mr. Perkins went into the dressing room. He selected the outfit, and then he put the new outfit in his person and left it out and then he left the he leave the his clothing inside the dressing room. And at that time, the store employee recognized the clothes that he wearing, and then she contacted the mall security, follow him. At that time, he fled the South Lake Mall.
And so he fled the South Lake Mall. The security guard told you wearing the clothing he had selected that he had not purchased.
I'm still listening. I'm still listening, Ms. Jefferson.
Okay.
Yes,
Okay.
ma'am. So after he put in a new outfit, so he left the store, passing the I'm sorry. So he passing all the point of sale without attempting to pay for the outfit. And at that time, the mall security approached him, and then he fled the store.
And when he fled the store, you said he went to the Olive Garden restaurant.
Yes, ma'am.
And when you encountered him, what happened? And sorry if I'm asking you the same question over and over again. I got a little discombobulated. What happened to support the facts for the obstruction charge?
So I asked him for his name numerous times, but he say go find out it, and he refused to give me his name. So I have to use the fingerprint scanner to find out who he is.
And did you determine who he was?
Yes, ma'am.
So your obstruction warrant was based on him not giving you his name?
Yes, ma'am.
Okay. I have nothing further.
Mr. Little.
Thank you, Your Honor. Officer Lamb, you said your basis for the shoplifting warrant is based on information you got from mall security?
Yes, mall security and the store employee.
Okay, so you did speak directly to the store employee.
I did, yes.
Okay. The employee said that they were able to witness this themselves, or is this from like surveillance camera or something?
They witnessed by herself.
Okay. Were you involved in the pursuit of Mr. Perkins from the mall to the Olive Garden?
No, sir.
You're talking,
The mall security did.
Okay, so by the time you made contact with him, he was already at the Olive Garden.
Yes, sir.
Okay. The clothing that he was wearing, did it have any tags or security items on the clothing?
It still have the tag.
Okay. Were the clothing taken for evidence?
After I take him go to the Clayton County Jail, so we able to remove his clothing, and I return that item to the owner.
Okay. Were like any photographs taken of the clothing or anything?
No, sir. It's gonna be on my body cam.
Okay, but you were in a body cam, I guess.
Yes, sir.
Now you say when you made contact with Mr. Perkins, he made statements to you?
Yeah, yes, sir. While I handcuffed him, so he say he wants me to send him to the prison. After he get out of prison, he will steal it again.
Did he tell you that he had any sort of mental health diagnoses?
No, sir.
It didn't come up in the conversation?
Nothing that I know of.
Okay. Those are the questions I have at this time.
Okay, any follow-up, Ms. Jefferson?
No, Your Honor, the state will rest.
Okay, I have one question. Is it my understanding that the obstruction charge is because he did not offer his name, Mr. Perkins?
what'd you say?
Ms. Perkins, that's not a question for you.
No, Mr. Perkins. I'm asking the officer. What was the basis of the obstruction charge? I guess that's a more direct question.
The obstruction charge that I charged him that he refused to give me his name after I asked him for his name numerous times. What he told me that he told me to find out that obstruction my investigation.
Okay. Ms. Jefferson, do you have any questions based upon the question I just asked?
I do, just a point of clarification. He was already detained or in custody in relation to the shoplifting charge when you encountered him to get more specifics about his name. Am I correct in that or no?
So when I encountered him, so I put him, I thought about the mall security and verified that was him. So I put him in the handcuff and then I start asking for his name, which he refused to do so.
That's all I have. Thank you.
Okay. Mr. Little, do you have any other questions based upon what the question I asked?
No, Your Honor.
Okay. May Officer Lamb be excused?
Yes, Your Honor, the state will submit on the evidence.
Okay. Thank you, Officer Lamb. Sir, you are gentlemen among men and your patience and being here. So you can be excused or you can stay if you want. Okay.
Yeah, I have returned back to work.
Okay.
Thank you, Your Honor.
Thank you. Have a good day, sir, and stay safe. So
Yes,
the
sir.
state has submitted on the evidence. Mr. Lane, I'm sorry, I put you out in somewhere by mistake in the digital universe. So I do apologize for that, but I'm going to come back to you in a second. Mr. Little, do you have any argument?
Your Honor, defense will submit on the evidence.
Okay. So I have a question. Mr. Perkins has a right to remain silent. And if he does not offer anything, does that form the basis of the obstruction charge? I have no questions about the shoplifting charge. But it appears to me that the obstruction charge is that he didn't offer to help the police, which he doesn't have a duty to do. So am I off base on that, Ms. Jefferson?
Your Honor, I would argue that the obstruction charge is appropriate as he was already detained and in custody in relation to the criminal act of theft by shoplifting. Had this been the reverse, where he was not detained or in custody as it relates to the theft by shoplifting, and the officer just walks up and says, you know, what's your name? Then that's a first tier, and then no, we wouldn't have any issue. But because he was already, because there had already been a criminal allegation or a criminal act, and he was being detained and in custody for that, and the officer was clearly in the lawful discharge of his duties, Mr. Perkins' failure to provide information to the officer in relation to the crime that he was being arrested for it is obstruction.
I'm gonna challenge you on that, Ms. Jefferson. And like I said before, if I'm asking questions, it's because I don't have the answer. Was he required to offer anything? I recall, again, getting to be an old man, but a person that was in Mr. Perkins' position in Fulton County 20 years ago, he'd be booked in as John Doe, and he'd be sitting there for a couple of days while they run fingerprints and try to figure out his identity. But I'm unaware of a duty to say anything when you're being arrested. Now, the things that you say may be held against you, which you'll be told. But if you say nothing, it's hard for me to figure out how that's a crime. But I'm gonna give you the opportunity to change my mind.
Your Honor, I think the key ingredient here is the custodial situation. I think that's the key ingredient. Like I said, had that encounter happened before, then I would have a weaker argument. But I think because he was already in custody, I think that particular circumstance matters in relation to acquiring information from the suspect or from Mr. Perkins and his refusal to cooperate with the officer and the officer's lawful discharge of his duties.
Okay, I'm gonna ask Mr. Little to respond, but you're gonna get the last word, Ms. Jefferson. Mr. Little, you heard my question.
Your Honor, as to the being in custody, I mean, when a person's in custody and they're being interrogated, that's the exact situation in which a person should be Mirandized, to be told specifically that they have the right to remain silent and don't have to provide information to the police when they're being questioned. So, I mean, had Officer Lamb Mirandized my client when he was brought into custody, then he would have been informed that he had the right not to give information to the police. He didn't prevent them from being able to identify him. He submitted to the being fingerprinted. They were able to identify him. But I mean, if this really turns on whether or not he's in custody, then I think that strengthens the idea that he would have the right to remain silent, because those are the circumstances under which a person would normally be Mirandized.
Ms. Jefferson, you get the last word.
I think that's a really good argument. I was sort of waiting, I was anticipating that would be your argument, Mr. Little. However, part of the arrest process, the booking part, asking questions, that's not under Miranda.
So again, it's the outward intentional deflection. It's the intentional interruption or the intentional obstruction, for lack of a better word, of the officer being able to carry out his lawful duties. He interfered with the process of the investigation, interfered with the process of the officer being able to do his job. That qualifies as obstruction, in my opinion.
No, I'm here to listen and to be educated. I'm gonna dismiss the obstructing an officer charge, but the theft by shoplifting, I find that there's sufficient evidence for that to go forward. It's the I guess the colloquial thing that I'll use as by way of example is, as a judge, I'm here to listen and to make a determination. Now, you can give me a 30-minute oration, or you can give me a 5-minute presentation, but you're not obstructing me in doing my job as a judge if you go 30 minutes versus 5 minutes. And so if a person lays down and officers have to lift that person up and take them to the car, I don't see that as obstruction. It's not something that I would recommend, but at the same time, if you arrest somebody, it's your job to, as Roscoe P. Coltrane would say, to cuff them and stuff them. And so the fact that you don't go along quietly, I don't see that as obstruction. And I could be wrong, Ms. Jefferson, but the theft by shoplifting is going to be bound over to state court of Clayton County to be tried. I'm dismissing the obstruction of an officer charge. Now, Mr. Perkins, you need to understand that Ms. Jefferson can go the next 30 minutes and write up an accusation and recharge this obstruction. The fact that I've made this determination in no way stops the state from moving forward if they believe that they want to proceed on that charge. So it may be a short-learned or short-lived victory, but for the moment, this charge is going to be, the obstruction charge is going to be dismissed, but theft by shoplifting is going to be bound over to state court. Now, Jackie Fleming, can we get Jackie Fleming on the screen?
In effect, yeah, that's the female. That's it. The lady carrying 4.
And Mr. Lane, I do apologize. I was trying to get you over into the same room with the jail, but I'll call it user error on my part, that I think I placed you in like a breakout room or something. So I still am going to get you in that opportunity in that room to speak to your client, but I do apologize.
Oh, no problem, Judge. I appreciate it.
Okay. Officer Kilgore, how are you doing today?
Good, Your Honor. Yourself?
I hope we haven't wasted too much of your day. It's after 11 now. Wow. I'm gonna try to get this stuff done. Miss Jefferson, with the cases where we don't have the officers here, I'm gonna start calling those cases in a minute. If the officer's not present, those cases are gonna be dismissed. With Officer Farley. That was a case I think we're waiting on. Was it you, Mr. Lane, to speak to your client?
Yes, Your Honor. Yeah, that'd be the case with involving Mr. Willie Williams.
Okay. And at the jail, my understanding is that Mr. Williams was supposed to be somewhere else, but he is present.
Yes, Your Honor. And I was actually visiting with him, and I guess we were back there with all the people we had to meet with, and we got timed out, and it just automatically put us all back into court with everybody.
Okay. So Officer Farley, I'm sorry, I'm gonna have to give Mr. Lane the ability to speak with his client, but we're gonna call case of State of Georgia versus Jackie Fleming. And this is position 6 on my calendar. And Ms. Fleming is charged in warrant number 2022 WA08006 with committing the offense of simple battery, family violence, and charged in warrant number 2022 WA08007 with committing the offense of criminal trespass, damage to property. Ms. Fleming is here represented by Mr. Little, and the state is being represented by Ms. Jefferson. Ms. Jefferson, you can swear in your witness and proceed with your examination.
Officer, if you could raise your right hand to be sworn in. Do you swear or affirm that the testimony that you're about to give in these proceedings is the truth and the whole truth and nothing but the truth, so help you God?
Yes, ma'am.
And if you could lower your hand and tell us your name and where you're employed.
So Officer Kilgore, employed with the Clayton County Police Department.
And were you so employed with the Clayton County Police Department on the 11th of May, 2022?
Yes, ma'am.
And were you dispatched to 3801 Anvil Block Road in Eaglewood, Georgia, Clayton County?
Yes, ma'am. It's Ellenwood, yes.
Oh, okay. Ellenwood, yes, I see that. And the basis for the warrants that were taken against Ms. Fleming, the battery and the criminal trespass warrants, could you provide us with those facts and particular information you obtained when you were dispatched?
Yes, ma'am. So I was dispatched to that location by the live-in manager of that residence. He said that one of the residents had been assaulting members of the staff. We get there and I made contact with the victim. He stated that he had tried to break up a dispute between the defendant and another employee there. And he said that the defendant had grabbed this other employee's purse, wouldn't give it back. He went down to break it up. And then the defendant attacked him, leaving visible injuries. He said that she punched him in the back and then scratched his head. He then showed me his injuries. It was a bruise on his back and a small laceration to the back of his head. He said after that she attacked him, they were able to separate, and then the defendant grabbed a vacuum cleaner and then swung it at him. It didn't hit him or anyone else, but it damaged the sheetrock. And then I saw the hole in the sheetrock.
And you said that she was a resident. What type of a residence was this?
It was a group home. That's what the information we provided. He said so. It was a group home.
Okay, so it wasn't a situation where they were connected by family. They were connected because this was a transitional type of residence?
It was a group home, and we charged her with family violence stuff because the victim was the manager that lived there permanently. So he informed us that he lived at that residence.
And she lived there
yes,
as well?
She lived there as well.
Okay.
Yes.
So you saw visible injuries on him?
Yes.
Did you see visible injuries on anybody else?
No, ma'am.
And you said that he said that she picked up a vacuum cleaner and swung it at him?
Yes.
Okay. And so was the vacuum, can you describe the vacuum? Did you see the vacuum cleaner broken?
The vacuum cleaner was not broken. I did see, if I remember correctly, some sheetrock dust on it, but the vacuum cleaner itself was not damaged. The criminal trespass charge was for the damage to the wall.
Okay, but you saw the damage to the wall?
Yes. Yes, ma'am.
Okay. And who identified the value regarding the damage to the wall?
I believe it was the victim. It was the victim or another employee there.
And you said the vacuum cleaner was not damaged. Was the vacuum cleaner, can you describe the type of vacuum cleaner it was?
I cannot recall, ma'am. It was just a standard normal vacuum cleaner. I don't know the make or the brand.
Well, let me ask you this. Was it a vacuum cleaner that stands up, or was it a vacuum cleaner that sits
The
down?
stand-up one, a normal stand-up one, and then you put your foot on it to lower or adjust the angle of it.
Okay. Did you happen to pick up the vacuum cleaner, or did anybody pick up the vacuum cleaner to give any indication as to how heavy it was?
Not that I recall.
And did you were the one that actually arrested Miss Fleming, and did she make any statements?
The only statement I can remember her making or recall making was that nothing happened.
That's all the questions I have.
Mr. Little?
Thank you, Your Honor. Officer Kilgore, you had a body-worn camera during this investigation?
Yes, sir.
Okay. And it's you personally interviewed the witnesses on scene for this?
Yes. I obtained statements from the victim and another witness.
Did they do written statements as well?
Yes, sir.
Oh, okay. Did any of them give you any indication of Miss Fleming's mental health status?
I cannot recall. I mean, it was a group home, so I'm sure there might be some mental health problems there, but I can't speculate on that.
Okay. The alleged victim in this case, I guess Mr. Hudson, he told you he lives there?
Yes.
Is his living space separate than the living space of the other residents of the group home?
Yes, I believe it was a multi-story house, and his is on the first floor, and hers is almost downstairs. It was like a split-level home.
Were there other?
So they don't live in the same room, but they live in the same address. I mean, not the same room. They live in separate rooms.
Would this be a living situation where they would share common areas?
Yes.
Like kitchens and bathrooms?
Yes.
Okay. Were there any other residents that lived on the first floor?
None that I spoke to.
Okay, so just as far as you know, Mr. Hudson was the only person that lived on the first floor?
Yes.
Okay. And he's an employee of the group home?
The manager of the group home was what he told us, or told me.
Do you know who owns the home?
I asked him, and he said he didn't give me a name. He said it was someone else actually owned the home, but he is the manager of the home.
Okay, but you weren't able to ascertain who the owner of the home would be?
No, sir.
Okay. Those are the questions I have at this time.
Okay. Any follow-up, Ms. Jefferson?
No follow-up, Your Honor. The state rests.
Okay. May this officer be excused?
Yes, Your Honor. I may have a brief argument, but yes.
Okay. Officer Kilgore, you can be excused or you can stay. It's at your leisure while I entertain arguments. So, Ms. Jefferson, are you gonna waive opening and just go to just final or?
Yes.
Okay, Mr. Little.
Your Honor, as to the criminal trespass, I would argue that we don't know who the alleged victim of that criminal trespass is. We don't know who owns this home to know who would be at a loss for the alleged damage. My other worry then is that we don't have also competent evidence of how much that damage would be worth. I know Officer Kilgore said somebody told him it would be about $200, but I mean, we don't know where that estimate came from, if it's just a wild guess. But more importantly, we don't actually know who owns that property to know who the alleged victim would be on this case. As to the battery family violence, my main argument on that is with the family violence component, Your Honor. The battery statute says that a case is a battery family violence if it defines household members as past or present spouses, persons who are living, persons who are parents of the same child, parents and children, step parents and stepchildren, foster parents and foster children, or other persons living or formerly living in the same household. My worry is, Your Honor, this living in the same household doesn't necessarily contemplate you living with someone who is paid to live in that household. The manager of this group home is an employee of the group home. This is their job to be at that group home and to live with these residents. Officer Kilgore testified that his living area was separate than the living area of the other residents at home. His room is on the first floor. The other residents are on the second floor, showing that they do have separate living spaces and they're not living together in the way that a family would live together for the purpose of the family violence statute. It's more like living in the same area as someone who's running the property. It'd be like living, you know, if a hotel manager has a hotel room near yours, it doesn't mean that you're living together as a family. That I don't think this is the type of relationship that the family violence statute is contemplating. So I'm not necessarily arguing against the battery probable cause, just the family violence component on that one, Your Honor.
That's a novel argument, Mr. Little. I would tend to agree with you on just the, I guess, the public side of your argument, the common sense side of your argument. I'll say that. But the statute says something different. And which I try to do is read the statute and follow what the statute says, whether I agree with it or not. So, Ms. Jefferson.
I appreciate Mr. Little's argument, but reading the statute, it says there's an or other persons living or formerly living in the same household. And I think looking at the text of the statute would qualify this under, you know, that particular section. That's the family violence battery. I think the evidence or the testimony was pretty clear that a battery had occurred. Visible injuries were there. The criminal trespass warrants, as it relates to the damage to the property, at this time, you know, the standard is, you know, is the probable cause standard. And I think there's sufficient evidence of the officer investigating to determine a value associated with the damage that was done by Ms. Fleming. But I do want to make another argument, and that relates to the questions around the swinging of the vacuum cleaner. This may be stretching it just a bit, but I do think that there may be sufficient evidence to bind this over as an aggravated assault. The statute 16.5-21 talks about an object, device, or instrument which, when used offensively against a person, is likely or actually does result in serious bodily injury. The officer testified that Ms. Fleming picked up a vacuum cleaner and swung it at him. She missed and she hit the wall instead.
Had she not missed, he would have been swung with an object when used offensively against the person is likely or actually does result in serious bodily injury. It damaged the wall. So had that been a body there, he could have received serious bodily injury. So I would ask that the court consider binding this over as an aggravated assault.
So, Ms. Jefferson, that is also a novel argument. I heard you ask about the weight of the vacuum cleaner, and I didn't understand where you're going with that, but now I understand where you're going with that questioning. I'm not going to bound it over as an aggravated assault, but you know and I know that whatever I do here as a prosecutor, you can undo. Not charging it as a felony, that's going to have to come from the district attorney's office. And so that may be over a drink of coffee or whatever that you convince someone on that argument. I would ask you to consider sort of a different step of backing down from some of the things or arguments as it relates to aggravated assault, because you're right in the sense that an object, and that's something we got to figure out. Whatever object, sometimes they say, "Oh, it's your fists," and that leads to aggravated assault charges. And I think we need to define our words more. So I'm not going to bound it over as a aggravated assault, but I am going to bind it over as a battery and criminal trespass, damage to property. Mr. Little, your argument as it relates to the ownership, that is that is a live issue. But the fact that I heard testimony about being a rooming house, that means somebody else has an ownership interest, and you don't have to have complete or whole ownership. You just have to have some ownership. And so I think that element has been met. So I'm going to bind this case over, both charges over, to the state court of Clayton County. And I'm getting tired, but we ain't even got to the criminal trespass discussion I wanted to have with you all. So we have before Mr. Lane, before I get to you, Miss Jefferson, this is the point in time where if these officers have not logged in, I'm going to call these cases and I'm going to dismiss them for want of prosecution. So we're going to begin with position number 1, Rashad Battle, and Officer Loudon. Do you have Officer Loudon available as a witness in this case?
I will sound for Officer Daniel Loudon. Officer Daniel Loudon.
Okay.
No response, Judge.
Okay, that's going to be dismissed for want of prosecution.
Your Honor, do you want me to prepare the order for that?
Yes, sir, please.
Will do, Your Honor.
Mr. Lane, this is your case. Jesse Bray, you had a pretrial. Was that a hearing? Oh, you're muted, Mr. Lane.
Yeah, on Jesse Bray, no, I was able to meet with him, and we're going to announce ready for hearing.
Okay. Ms. Jefferson, I have an Officer C. Headspeed that I do not see on the call. Do you want to sound for your witness?
Officer Craig Headspieth. Officer Craig Headspieth.
Okay.
No response, Your Honor.
Okay, that's going to be dismissed for lack of prosecution. We have an interesting situation on position 4, Lucky Brock. That's also Officer Loudon, but it looks like Mr. Brock, where I believe it's a Mr. Brock, is representing himself, and Officer Loudon is not here. So do you want to sound for Officer Loudon once again?
Officer Daniel Loudon. Officer Daniel Loudon. No answer, Your Honor.
Okay. We have Officer, looks like Christopher Joseph, that is logged on now for position 5, Marquise Busby. Who's handling that, Mr. Little?
David Sell, Your Honor.
That's going to be you, Mr. Sell?
Yes, sir.
Okay. So we have the officer. I'm going to come back to that, but I'm going to finish sounding for these cases where it appears that the officer hasn't appeared. And we have, looks like Officer Cruzline. So Officer Joseph and Officer Cruzline, it appears, are going to be our last hearings for today. And I'm just going over my calendar. All right, with Mr. Williams over at the jail, were you able to get contact with Mr. Willie Ernest Williams Jr.?
Williams.
That was a case where I believe that he may have been in another courtroom, and it may have to be continued because he's in another courtroom. Okay.
Actually, Your Honor, Mr. Williams, this is the same Mr. Williams I was meeting with, and our meeting got cut short.
Okay.
So
Okay. Mr. Williams, I am going to I'm going to do a hearing, but I'm going to place you in a breakout room soon so that you can speak to Mr. Lane, and Officer Farley is who I have, and Miss Jefferson. I'm gonna. Oh, Miss Farley is still, looks like she's still here. So I'm not gonna hold you up or harangue you with that case because Officer Farley has been waiting here patiently.
Yes, sir.
The Dominique Alexander, that's going to be continued to June 7th. Is that your understanding, Mr. Sir?
That is correct, Your Honor.
Okay. I have a Khadijah Delaveau with an Officer Bowling, and I don't see an Officer Bowling. That's your case, Mr. Little.
It is.
Miss Jefferson, do you want to sound for Officer Bowling?
Officer Evan Bowling. Is there an Officer Evan Bowling? Your Honor, this is these are charges of battery and assault. These are charges, against a person. We would ask that be continued to the next calendar, the next available calendar, because of the nature of the charges.
Your
So
Honor, I
that
would
we have
point
an
out,
opportunity to get the officer.
and Your Honor, this is the third time Ms. Delaveau has been on a preliminary hearing calendar. She was here on May the 10th. She was here on May the 24th. She was here on today, May the 31st. And every one of those times, Officer Bowling didn't arrive and the state asked to continue it to allow him to have a chance to find Officer Bowling. This is the third time, Your Honor. We would ask that this be dismissed.
Miss Jefferson, what's your response?
Your Honor, I'm not privy to the prior actions. I'm just looking at the nature of the charges. And it would, we would ask that the court allow another opportunity because of the seriousness of these charges, that the case be continued one more time.
Ms. Jefferson, I think based on the knowledge that I've been told there's been 3 times, I'm gonna dismiss this for warrant of prosecution. Of course, you can bring charges back at any point within 2 years of the alleged crime. Mr. Little, I need you to present me with a dismissal order.
Hearing it now, Your Honor.
That I will sign. And and this is something that I would really want to know, Ms. Jefferson, and we can talk about it offline, about just how the charging procedures go, because I've heard certain things about how charging happens, and it comes and your hands may be tied in the solicitor's office or the DA's office before stuff moves out of magistrate court. So I don't understand that process, but I'd love to understand it because, you know, as a prosecutor, you can charge a case at any time when you believe you have the evidence that's there. And I'm not saying you personally, but just you standing in your position as an assistant solicitor. And I was told that for some reason, based upon the computer system or whatever, that's not possible. But I really would love to hear from your side how that whole process works. So maybe we can have that conversation in conjunction with
Your Honor.
Trespass. Yes, sir.
So what's the name of the individual that case got dismissed?
It is Mr. It's well, maybe Miss Khadija Deleveau, Deleveaux.
Okay, sir.
Okay. All right. Thank you. Mr. Corey Morgan. It looks like the witness is Shanta. It says LAT Franklin. Go ahead.
I got information from the investigator that the officer was on the Zoom.
Okay.
I'm not sure where now, but I got information a few moments ago that the officer was present.
Okay.
Let me just check with them again to make sure.
Yeah. Yes, ma'am. And I'll give you that opportunity. Sanchez Simmons. This is a case that I think is Mr. Lane's case, but there's a need for an appointment order.
Yes, Your Honor.
Is that correct? We have Officer Cruz Leon on. Are you, Mr. Lane, ready to go forward on that case?
Yes, Your Honor.
Okay, and I'll do the appointment order.
I'm knocking on the door.
So we're gonna, before we bring up Simmons, we're gonna bring up the case for Officer Farley. Let's see. So based upon what I have now, looks like we got 3 more cases to go. Marquise Bushby. Sorry, I'm gonna call Officer Farley's case first. And I just gotta get to the name. Willie Ernest Williams. Are you Miss Williams?
Yes, sir.
Okay.
There we go.
And this is going to be your case, Mr. Lane.
Yes, Your Honor. And this was the one that I was needing to speak with Mr. Williams real briefly. Real quick.
Okay. All right. Stand by. Stand by. I'm sorry.
Shouldn't be long, Judge.
It's we got Officer Christopher Joseph, Marquise Busby as Mr. Suh's case. I'm gonna try to get these out of the way, Mr. Lane, just so you can speak to your client, and that'll be the last thing that we'll do. So at the jail, Mr. Williams, you can go off camera. We're gonna bring up Mr. Marquise Busby, B-U-S-B-Y. And we have Officer Joseph here. I think I've been told I need to drink protein drinks, the Snapple and don't tell Miss Mary, I know she's listening, but the occasional Coke, or the Coke drink, not the not the pharmaceutical Coke.
I'm probably looking for a new assistant soon.
See how Miss Mary do me? But I gotta, I start my day at 7. And I'm getting prepared and all this stuff to be ready to look beautiful for you guys on camera. And witty and all the other stuff that I try to do. Okay. You are Mr. Busby, correct? Mr. Busby, this is going to be your preliminary hearing today. And for the record, it's the state of Georgia versus Marquise Busby. Mr. Busby is charged in warrant number 2022 WA-08193 with committing the offense of battery. He's represented by Mr. Suh, and the state is represented by Ms. Jefferson. Ms. Jefferson, would you please swear the witness in and present your case?
Officer, can you raise your right hand? Do you swear or affirm that the testimony that you're about to give in these proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, thank you. Can you lower your hand? This is a little unusual because your cap is shielding your face, so I don't see anything.
Oh, I'm sorry.
Okay, yeah, now I can see your face because there was just a void there. Okay, officer, where are you employed?
Well, Clayton County Police Department.
And were you so employed on May 16, 2022?
Yes.
And did you respond to 2507 Rex Road in Ellenwood, Georgia, in Clayton County to a domestic dispute or domestic disturbance?
Yes.
And can you tell us the basis for the family violence battery charge that you filed against Mr. Busby?
Yeah, so when I arrived on scene, I saw the victim, Veronica, with a huge knot on her forehead. Pictures are attached with the report. and she said she sustained that knot on her forehead from Mr. Busby grabbing her by the neck and throwing her down to the ground, and she hit her head on the door frame.
And what was the relationship between her and Mr. Busby?
Boyfriend and girlfriend, and she's pregnant. She's 7 months pregnant with his child.
I'm sorry, you said that you took photos as well?
Yes, they're attached to the report.
I have nothing further.
Mr. Sir.
Thank you, Your Honor. Good morning. I guess good afternoon, Officer Joseph.
Hey, good afternoon.
All right. So it looks like in your report you indicated that Mr. Busby stated that that injury occurred a different way. Could you please tell us more about that portion of your report?
Yeah, he claims she was sitting on a washing machine, and she attempted to get up, and she slipped and she fell.
Did you go ahead?
No, I was going to say, but she denied that. She denied that that's how it occurred. And I don't know if you saw the picture, but it's not consistent with someone slipping and falling. It looks like an injury more so that was done by an individual.
And how did you determine that? How did you come to the conclusion that it was an injury that occurred by a human versus a doorknob?
Because she also had other injuries to her body. She had some bruising, some scratches, some bruising on her neck as well.
Okay.
Consistent with her stating that he grabbed her by the neck and threw her to the ground.
Now, the alleged victim, Miss Graves Smith, she indicated that they were in a altercation before things got physical. Is that correct?
Yes.
Okay. And did she mention any attacks that she gave, any mutual fighting that occurred?
In that current incident?
Yes, correct.
I believe she did say she did something, but it was to defend herself.
So she claimed that she was defending herself?
Yes.
What about the portion that talks about the pepper spray? Could you tell us more about the pepper spray in your report?
Yes. So he mentioned that she did use pepper spray, and we went into the home. We went into the room. We took him to the room that he, alleged she used pepper spray on him. And pepper spray lingers around. And myself and two other officers, along with Mr. Busby, was in that room, and there was no sign or indication that pepper spray was deployed. And Mr. Busby showed no signs or indication that he had been pepper sprayed. Nothing was wrong with his face, his eyes. He looked perfectly fine.
About how much time would you say passed between the time the call came into dispatch and the time that you were able to arrive at this location at Rex Road?
Probably anywhere between 10 to 15 minutes.
Did you check Mr. Busby for any injuries on his body, his person, his neck, anywhere on him, the defendant?
Not that incident. So we responded multiple times to this location. Mr. Busby did sustain a few minor scratches on him, but from an earlier incident.
Are we talking about the same night, the same evening, or a completely different day?
Well, it was before midnight.
Okay, so within, I guess more specific, was it like within a 12, 24-hour time period? That
Yes,
okay,
yes, it was.
Okay. this is probably my final question. Did you find any pepper spray in the vicinity at all?
No.
All right. That is all the questions I have at this time.
Okay, Ms. Jefferson, do you have any follow-up?
Just one question. From your investigation and from your questioning both individuals, who did you determine was the primary aggressor?
Oh, is that, you're talking to me?
Yes,
Ms. Jefferson?
sorry.
Oh,
Yes.
oh, repeat the question, please.
From your investigation and from your inquiry and questions asked, who did you determine was the primary aggressor?
At this particular incident, Mr.
Yes,
Busby.
the incident that occurred 16th of May.
Yeah, Mr. Busby.
Thank you. Nothing further. The state rests.
Any follow-up, Mr. Saw?
No, Your Honor, not this time.
Okay, may Officer Joseph be excused?
Yes, Your Honor, and the state will submit.
Okay, Mr. Saw, do you have any argument?
No, Your Honor, we have no witnesses, and we will submit on the evidence as well.
Okay, based upon the testimony that I've heard, I'm gonna bind this case over to state court of Clayton County. And Officer Joseph, you can be excused, and Mr. Busby can go back to his housing area. Now, from my calendar, I have Williams, Morgan, and Simmons as the three cases that are remaining. Is that correct?
Correct for Morgan?
I think there's a
What's his-
position 46.
Probably in 2 weeks,
Okay.
unless you get just out out. That's the best thing to do.
He's a fucking liar, man.
That's Tracy Mathis.
Yes, Your Honor.
Your Honor, I submitted a order for a judicial bind over due to her mental health status.
Oh, that's right. That's right.
Yeah, yeah.
Sorry, I forgot about that.
That was a note. That was a note that I have. That there's Mr. Little's going to try to find bed space for this person, but
We can do that from state court, Your Honor.
yes, sir.
Yeah, yeah.
So Simmons, Morgan, and Williams, and Mr. Lane needs to speak to Simmons
Williams.
and Williams, or just, is it just Williams?
Just Williams, Your Honor.
Okay. So with position 48, Ms. Ferguson, Corey Morgan, I don't see.
You called me Ferguson again. That slipped out.
I did. Did I do that?
Yes, you did.
Oh my God. Oh my God. I'm gonna have to sit on a psychologist's couch somewhere. It's why I'm calling this lady I met for the first time. I keep calling her Ferguson.
Well, Your Honor, as it relates to Corey Morgan, unfortunately, I was mistaken. Investigators and victim advocates. Officer Franklin is not on.
But you're breaking up. I didn't hear anything after Officer Franklin is not something.
Yeah, my internet's getting tired. Officer Franklin, unfortunately, I was mistaken, and I do not believe Miss Franklin, Officer Franklin.
Miss Jefferson, not Ferguson. You're breaking up. So
Still?
I need you to, yes, I need you to say it in short form. not long form. So what are we doing with Corey Morgan?
Officer Franklin is not on the call. However, this is a very serious offense of battery, and we would ask that that be continued to the next available calendar.
And Your Honor, if I may chime in now, Your Honor, this is our third time being here as well. We've had a preliminary hearing on the 10th of this month, the 24th of this month, and we're here today. The previous two preliminary hearings, no excuse was given as to why there were no officers or there were no witnesses, except that they were not available. Nothing about training, anything that would allow the court to have an excuse to continue the case. The case has already been continued twice because there has been nobody present to testify against Mr. Morgan. And we are asking again, and the third time, there's nobody here. I mean, if this was a serious enough case as been stated, then where are the officers? Shouldn't they show up for such a serious case? Your Honor, we're asking that the charges be dismissed for lack of probable cause. He is in for 1 count of battery. And as I said before, Your Honor, no excuse has been given as to why the officers are not present. And this is the third time, Your Honor.
Ms. Jefferson, I think I'm gonna have to agree with the defense. I don't take any pleasure in this because I don't know this person. And I don't know what this person is gonna do. I know the charges, I know the allegations, and God forbid this person is released and they do something else. And I know I'm going to be the person that's going to be blamed for it. But if this person was arrested, officers should at least make it to court. And I don't, like I said, I don't take any joy in that, but my job is to look out for the interests of both sides, not just one side. So I'm going to dismiss this case for warrant of prosecution. Mr. Sub, would you present a proposed order?
Yes, Your Honor. Absolutely.
And share it with Ms. Jefferson.
Absolutely.
And there's.
Your Honor, what's the gentleman?
I'm sorry.
So what's the gentleman name?
Mr. Corey Morgan.
Okay, sir.
Okay. So now that leaves us with 2 cases that are Mr. Lane's cases. And I'm going to place Mr. Lane. You said there's only one client, though, that you need to speak to. Is that correct?
Yes, Your Honor, that's Mr. Williams.
So can we move forward on Mr. Simmons or Mrs. Sanchez Simmons?
Yes, Your Honor.
Okay, we have Officer Cruzlan here. So Officer Farley, it looks like you're going to be the last person today. If you got to blame somebody, blame Mr. Lane. I'm certain you can find his address and go just sit outside his house. So at the jail, we need Sanchez Simmons. Is that the person standing before me? You're muted, sir, so I can't hear you. You're muted. I cannot. So, sir. Sir, I just wait until we unmute it, and then.
Yes.
Yeah, okay.
No, I'm Willie Wood.
Willie. Okay, sir. You're gonna have an opportunity to speak with your lawyer, Mr. Lane, before we go forward with your hearing.
Yes, sir.
But I'm gonna do Mr. Sanchez Simmons now,
Yes,
or
sir.
Ms. Sanchez Simmons now, and then just stand to the side
Yes, sir.
And just tell him I need Sanchez Simmons.
You want Simmons?
Yes, sir.
Okay, sir. Mr. Simmons? Simmons?
Mr. Lane, the older I get in life, I just like to spend time with my chickens. That's how my chickens, they're judgmental as anybody else. But they're lovely animals. So we have Officer Cruzline. For the record, it's going to be stated position 49, State of Georgia versus Sanchez Simmons. Ms. Simmons is charged warrant number 2022 CW 51803 with committing the offense of criminal trespass. Mr. Simmons is charged in warrant number 2022 CW 51804 with committing the offense of battery. And Mr. Simmons is charged in 2022 CW 51805, but I don't have a charge. What's the charge in that?
That's child cruelty, 3rd degree, Your Honor.
Okay, child cruelty, 3rd degree. Mr. Simmons is present. He's represented by Mr. Lane. State's been represented by Ms. Jefferson. Ms. Jefferson, you can swear in your witness and present your case.
Officer, your hand up. Do you swear or affirm the testimony that you're about to give in these proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand. And if you could state your name and tell us where you are employed.
I'm Officer Cruz Leon with the Forest Park Police Department.
And were you so employed on the 10th of March, 2022?
Yes, ma'am.
And did you respond to 1409 Rock Cut Road, Sheridan House Apartments, to a domestic disturbance?
Yes, ma'am.
And what city is that located in?
The city of Forest Park, ma'am.
And is that in Clayton County?
Yes, ma'am.
And can you tell us the basis or the facts that support the warrants or the charges of criminal trespass, damage to property, battery, and child cruelty in the 3rd degree against Mr. Simmons?
Yes, ma'am. So on Thursday, the 10th of March, I responded to 1409 Rock Cut Road, which is the Sheraton House, apartment Charlie 1. I met with Alexis Bryant, who stated that her friend Sanchez Simmons was no longer on scene and choked her and broke her TV.
Okay. And can you tell us about how she's saying that she was choked? Can you give us a little more information on that?
Oh, yes, ma'am. So it began with them arguing, and then he broke her, I guess, threw her TV down to the floor and stepped on her, breaking it. And then I guess they began arguing, and then he got her on the chokehold, the one-hand chokehold, because I guess he had her phone. And then when she got loose, she ran to the kids' room, and that's when he followed her.
Hold on, Officer. Is it Cruz Leon?
Yes, sir.
Okay, Cruz Leon. Mr. Simmons, I saw you raise your hand. Sir, and I forgot to admonish you or just warn you that whatever you say during this proceeding is not privileged or private. It's best to speak to your lawyer first before you try to make any kind of statement. At this stage in preliminary hearing, the standard is really low. It's a probable cause standard, which is a 51%, if that's what you're thinking about. So is, could it have happened? Not that it happened directly the way that a person is testifying or any of that kind of stuff. Purpose for this hearing is for me to listen to the testimony. And then you can speak to your lawyer and let your lawyer advise you as you move forward, because it really is a small standard. So don't get yourself in trouble by saying stuff now, just because you're trying to make a point. But if you haven't spoken that over with your lawyer, you may say the wrong thing unknowingly. But you have the right to speak. And so if I do not pressure people into speaking or whatever, but just understand that the officer is here to say what the officer observed and saw. And the prosecutor is asking questions along that realm. This is by far not a trial. So it's generally best not to say stuff unless and until you and your lawyer have spoken about it. And I understand that you were unrepresented, and Lister and Holt has agreed to come on and represent you. So I would just ask you and possibly beg of you to don't put yourself in any deeper trouble. Do you understand that, sir? Oh, okay. And I'm sorry. Go ahead, Officer Cruzline. And I'm sorry, Ms. Jefferson, I interrupted your direct examination.
So I think the question, officer, was about, she said that she was choked, and I was asking you if you could provide more information as it relates to her saying she was choked. Did you see visible marks on her neck? Did she describe the manner of the choking?
No, ma'am. I didn't see no physical marks, but she decided he grabbed her like that. I guess her head was in here because he had her phone. I guess he was trying to take her phone, and she was trying to grab her phone, and he wouldn't give it to her. So I guess when she came for it, I guess he put her in a chokehold. So it was not with the hands, but more with the like that, like grabbed her in chokehold like that. She was able to get off, and I believe he ran or she ran to his room, to the kids' room. The guy ran to, yeah, she was able to get off, and Mr. Sanchez ran to the kids' room, and Miss Bryant followed, and I guess that's when they began to wrestle in front of the kids.
And the rest, I'm sorry, the wrestling was over the phone, over getting her phone back?
Yes, ma'am.
Okay, so how did she describe how he actually took the phone? You may have said that. If I'm repeating myself, I'm sorry. Did she describe how he actually obtained the phone?
No, ma'am.
All that you were aware of is that he had the phone and she wanted to get the phone back. Is that correct?
Correct, ma'am.
Okay. Now you said something about a television that was damaged.
Yes, ma'am. So she stated that Mr. Sanchez threw her television to the floor and stamped on it.
And
I guess he was mad.
Do we have any information regarding the type of television or the value of that television?
Yes, ma'am. Pictures were attached, and she didn't know how much it cost because it was a gift. So she said basically like $300.
Okay. And who were the witnesses to, not necessarily just the stomping on the TV, but the chokehold?
Nobody that I'm aware of.
Were there children involved or children present?
At the time of the chokehold, no. I believe the time when they went into the kids' room to wrestle, yes.
I'm sorry, you said that when there were children involved, when they went into the room to wrestle?
Yes, ma'am.
Okay. And
Not the
that
time
was,
of the chokehold, nor the TV was damaged.
so what happened in the presence of the children then?
She just stated that they wrestled for the phone.
Okay. And their relationship, they were not living together, sharing the same household, is that correct?
Correct. She stated that they were just friends, and he had asked her if she could spend a week with them, that he will pay them, but he was only there for one night. That's why I didn't put the family violence, because he only lived there. He only stayed for one night.
Eventually, did she retrieve her phone?
Yes, she did have her phone.
I have nothing further.
Okay, before we get started with you, Mr. Lane, Mr. Simmons, I did see you raise your hand again. I have to tell you, everybody that has been accused of a crime where the charges were eventually dismissed or they were acquitted at trial have gone through this process. And I've observed your emotions and the stuff you're doing. And sir, if you want to speak, I will allow you to speak, but you really should not speak unless you've sat down with Mr. Lane and told Mr. Lane everything that is on your side and what you're trying to bring forward. Because if you say something today, this is being recorded. And Ms. Jefferson and the people in her department, they will nail you to the wall with the words that you say. And you got to understand, if you want to do it, you can do it. But, and I'll let you do it. I mean, even Mr. Lane can't stop you from talking if you want to talk. My job as a judge is to let you talk. But this is being recorded. You can't take those words back. You can't say, well, what I had meant was. You can't do that. So I'm just trying to tell you, young man, don't get yourself in deeper water, deeper trouble, or whatever. Speak to Mr. Lane. Let him represent you. You may disagree with whatever you have to say, but Mr. Simmons, okay. Mr. Lane, I'm gonna let you ask the questions that you have. And Mr. Simmons is muted. But after you're done asking your questions, I'm gonna open up the microphone and he can say whatever he wants to say.
Okay, Judge, and I appreciate it. And just for the record, I did advise him that for him not to talk and to remain silent. And this is not a trial today. It's simply a preliminary hearing. We're not putting on any evidence. And but I understand that at the end of the day, it's his right if he wants to speak, but I've warned him and I've advised him strongly to remain silent during these proceedings. This isn't the time. And I know you've reminded him more than once and cautioned him, but at the end of the day,
if he wants to hang himself, he can hang himself. As they say, it makes me know, never mind. I really believe in the law, and I really believe in my job, and really believe in trying to do what I'm supposed to do. But at the end of the day, adults are adults, and they make their own decisions. but go ahead with your cross-examination of Officer Cruzline. And I'm sorry, Officer Cruzline, I know you've been waiting. But
Okay.
Thank you,
ahead.
Judge. Good afternoon, Officer.
Good afternoon.
Did you find it unusual that the alleged victim here didn't have any injuries?
I mean, all she said was he got her in a chokehold like that. I don't ever seen somebody have any injuries from that. I don't think he pressed on it hard. I think he was just, because I guess she came at him, so maybe he did that, but I'm not sure.
So, but maybe he wasn't choking her.
Maybe he was, I don't know. That's all she said, that he put her in a chokehold. I'm just solely going by what she said.
But there weren't any injuries, correct?
No, sir. I did state it on here. I did ask if she had any injuries. She said she didn't have any.
Okay. And did you interview Mr. Simmons to find out his version of what happened?
No, he was already gone by the time I got there. I had asked her to call him, but he wasn't answering.
Okay. And it looks like you did take pictures of the broken TV.
Yes, sir.
Would you be willing to turn those pictures over to the defense?
Sure.
Okay. And did you ever determine who the owner of the television was?
She said that somebody gave it to her as a gift, that it was hers.
Okay. And the children were not present when the television was broken or during the alleged choking. Is that correct?
No, sir. They were not present.
Okay. All right. I don't have any further questions, Your Honor.
Okay, Ms. Jefferson.
Officer, how old were the children?
Oh, let's see. I know they were below 7 years old. There was two of them, a boy and a girl.
And just so that I absolutely understand, they were present during the
wrestling. Yes, ma'am.
during the wrestling. Now, did she say that during that wrestling, did she make any allegations that he struck her, or
No, ma'am.
they were just wrestling over a phone?
Yes, ma'am. She was trying to get his phone, and he wasn't trying to give it to her.
Okay. That's all the questions I have. And I do have, well, I'm sure that there's going to be argument regarding this from the defense. But I do have some issues as it relates to the warrants.
Okay. Officer, let me ask you, because I may have been distracted. What's the basis of the criminal trespass?
So the criminal trespass for the TV, criminal trespass damage?
Yes, sir. That's where you allege that he jumped on the TV?
Yes, sir.
Stomped on the TV? Okay. And battery, there's an allegation that she, the victim said that he strangled her, but you did not observe any like marks.
I didn't. I've looked, but I didn't see no marks.
Okay. And for the child cruelty, that's because there was young children that was in the room seeing them
wrestling with the phone. Yes, Your
over the phone. Yes, sir. Okay. Ms. Jefferson, Mr. Lane, do you have any questions based upon the questions that I asked?
I do, Your Honor. How large was the residence when this occurred?
So I believe it's a 2-room apartment.
And the children were in another room when the choke occurred, when the stomping of the television occurred. Is that accurate?
Yes, ma'am. Because I believe it was 8 in the morning.
Okay.
So I believe she got up to get the kids ready, went back to the other room, and then that's when it happened.
Okay, so being that the size, it was an apartment?
Yes, ma'am.
Okay, being that the size of the apartment was small enough, the children were in earshot of the commotion
occurring between the two of them regarding the TV stomping and the choking?
Possibly, but they didn't, to my knowledge, they didn't witness it.
Okay.
That's all
Mr.
I know.
Okay, Mr. Lane, you should be made aware that Mr. Simmons was pulled off of the camera feed because he just was not comporting himself in a manner that he should, and he was essentially making allegations that people are making up stuff. So he has, through his behavior, decided to exit himself from this proceeding, and I was going to give him the opportunity to speak, but that's going to be lost. So I'll hear argument.
Thank you, Judge. As for the simple battery, of course, we're just going to argue that there was no probable cause met on there. There weren't any injuries, there weren't any markings made, and the officers testified to this. And as to the cruelty to children, again, the TV being broken and the alleged choking, none of that was done within the presence of the children. And as the officer testified, even stretching it to quote unquote earshot of this going on, he couldn't and didn't say that they were even within earshot. He just simply said it was possible. So just on the cruelty to children and the simple battery, we'd ask both those charges be dismissed. And the criminal trespass damage to the television, would argue for the dismissal on that, just for lack of a solid value to the TV, or how much damage are we talking about of this television?
I was about to call you Miss Ferguson again, Miss Jefferson. At least I'm learning.
Your Honor, the officer did testify as it relates to the value of the television that was broken. She then said, or she told the officer that the value of the television was at around $300 as a gift. The children it was a two room area apartment. And it was an apartment, not a house, so the walls presumably were thinner. With the commotion that was occurring around the stomping of the television and the chokehold, I'm sure that they were not silent. So I believe, even though the officer said probably as it relates to hearing and earshot, and the statute, does allow for that as far as seeing, hearing, for the third degree child cruelty. The simple battery she said that he choked her with his arm area, and that was an offensive touching. And the simple battery does not require a visible injury. There is the issue regarding the phone, though. He took the phone. They were fighting over the retrieval of the phone. That to me could be a theft, but I'll leave that with the court as it relates to that. And that's my argument.
Okay, well, I'm going to bond over the charges as they are presented. The testimony about the stumping on the TV is enough for the criminal trespass. The battery is written on my document as like battery school personnel. Testimony of the officer is like simple battery, where there's offensive touching, but officer did not describe seeing any marks. But that's the testimony that he was, or the statement that he was presented with. And I'm going to leave it over to the, child cruelty in third degree. And the thing, Mr. Lane, with your client is if people can't comport themselves in a courtroom setting, I just can imagine what they do behind closed doors. And the allegations that are made are serious allegations. And if he can't, as they would say, hold his powder and remain quiet until he gets an opportunity to speak, I can't imagine what he would do behind closed doors. So I've been in your shoes, sir, and I do not, well, I have compassion for you and what you may be going forward in dealing with this case. It's, this be last bit of personal privilege. What I will always tell people, if you spent this amount of time educating yourself before you were in jail, maybe you wouldn't be in jail. But you're in jail, and I went to college and law school, and you're trying to tell me what the law is. And from people that have told you certain things or whatever. But so I'm going to stop because we got to get you into the room so that we can stop wasting Officer Farley's time. Mr. Cruz Leon, sir, thank you. You're free to go.
Thank you, Your Honor.
Today. I see Ms. Ferguson and Officer Bowling.
Just gonna make that a laugh. It's just funny, Ferguson. I mean, maybe I should just change my name. You did. And I'm thinking I'll just change my name for purposes of this Zoom. I'll change the bottom where it says Deborah Jefferson to Deborah Ferguson.
Well, ma'am, you have my permission to tell the whole world how much of a dumb behind I am that I can't remember your name, and I don't even know I'm saying it. And that's the crazy thing. Mr. Little, I thought we're done with you, sir.
Oh, I was going to hang out to the end of the calendar, Your Honor.
You see, I'm gonna start charging tickets. There's Miss Jefferson, not Ferguson. Since Mr. Little don't want to join me in on my little project of, I say, Zoom Chronicles, because you can't imagine the stuff that we see and the things that we deal with. Over at the jail, I'm gonna send Mr. Lane. Where are you, Mr. Lane? All right, I'm going to attempt to place Mr. Lane in breakout room 2, and I'm going to attempt to place jail in breakout room 2. Mr. Lane, you're gonna miss the story about the criminal trespass, because I'm gonna spend that time speaking to Mr. Little, Mr. Suh, and Miss Jefferson, and maybe Miss Bellow, if she can stomach having a conversation with me. Okay.
Your Honor, it says you've been assigned to breakout room 4.
Let's see. Yes, you are in breakout room 4. I'm going to move you to breakout room 2, just to try to avoid the problem we had before. So it's showing now that you and Mr. Lane and Mr. Sud, Mr. Little are all in breakout room 2. Okay, let me